In the case of Hadley and Baxendale, an engine component, namely the crankshaft in the claimant's mill, had broken. The claimant therefore organized for it to be repaired. The claimants hired the defendant to transport the crankshaft to the repairers and for the defendants to deliver the crankshaft back after it has been repaired. However, the defendants delivered the crankshaft late, and due to that delay, the claimant's mill could not run at all, and the claimants lost substantial profits and business. The claimants therefore sued the defendants for breach of contract to recover those lost profits. The defendant argued that the loss suffered by the claimant was too remote, as it was unreasonable for the defendants to know that the late delivery of a crankshaft in breach of the contract would render the entire business of the claimants inoperable. At trial, the jury, under the direction of the trial judge, allowed the claimants to recover the lost profits. The defendant appealed. Before going to the decision of the case, it is worth setting out the background behind what this case is all about. You might know that compensatory damages for breach of contract come with certain limits, and one of those limitations is the doctrine of remoteness. If the loss was too remote, then that loss and the damages that correlate to it won't be recoverable. However, if the claimant's loss was not too remote from the defendant's breach of contract, then the claimant would be entitled to damages for that loss. The question, therefore, is how do we draw the line between remote loss and non-remote loss? Baron Alderson gave us an answer which formed the basis of the remoteness doctrine in contractual damages for many years and has been subsequently modified and interpreted in subsequent cases. He held that where two parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect of such breach should be such as may fairly and reasonable be considered either arising naturally, i.e., according to the usual course of things from such breach. This has been known as Limb 1 of Anderson's test for remoteness. Or such laws as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract. In other words, if it was reasonable to assume that the defendants had in their minds that such a loss could probably ensue from their breach of contract, then such loss would also be recoverable even if it was such loss that may not come about in the usual course of things. This has been known as Limb 2 of the Anderson test. He went on stating that if the special circumstances was actually communicated by the plaintiffs to the defendants and thus known to both parties, the damages resulting from the breach of such a contract, which the defendants would reasonably contemplate, would be the amount of injury which would ordinarily follow from a breach of contract under these special circumstances. So this was the point made earlier. But, he said, if these special circumstances were wholly unknown to the party breaking the contract, he at the most have had in his contemplation the amount of injury which would arise generally from such a breach of contract. In other words, if the defendants had no clue about these special circumstances, then the claimants can only rely on Limb 1 but not Limb 2 to recover the damages. And this was because such special loss, would neither have flowed naturally from the breach of this contract in the great multitude of similar cases, nor were the special circumstances communicated to or known by the defendants. In this case, Baron Anderson didn't come to a conclusion on the facts and had instead directed a retrial on the grounds that the trial judge had misdirected the jury for using the wrong test. As mentioned, The Hadley and Baxendale test for remoteness has been refined and reinterpreted in later cases, but the original test is as follows. In summary, a claimant's loss is not too remote if the loss arises naturally from the breach of contract in the usual course of things, or the loss may reasonably be supposed to be in the contemplation of both parties at the time the contract was made, as a probable result of such a breach.